Good afternoon all, and thank you for joining us for this half-hour session looking at force majeure clauses in commercial contracts and in a COVID-19 context. My name is Nick Ashcroft. I'm a partner in our commercial disputes practice. I'm joined today by Gareth Jones. He's the architect of the force majeure toolkit, which I'm sure many of you have seen. You should also receive a short slide deck in advance of this call, but don't worry if you do not have it to hand, because the slides will be on the loop-up screen and we'll be circulating a fuller version at the end of the call. Thank you also to those who provided questions in advance. We will look to address them as we go through the session. There's also an opportunity to send further questions by email afterwards, and we may run a follow-up session if there are any particularly thorny issues that we think people will find helpful to discuss in this type of forum. For the majority of this session, we're going to unpack the 5 stages of any force majeure analysis, which you can see on the screen now and is summarised on page 2 of the slide deck that you've been sent in advance. Force majeure questions are highly fact-sensitive and dependent on the specific wording of the relevant clause. There are no general answers. However, there are some key themes, and following these 5 stages of analysis should get you to the right result at the end. So Gareth is going to kick us off with stage 1, the obligation.
Good afternoon, everybody. It may seem like an obvious place to start, but it is vitally important to define with specificity the obligation in question, which may or has been prevented or otherwise impeded by the force majeure event. And that's the case for 2 reasons. The first is legal. It's obviously vitally important when we come to stage 3, the question of causation, that we've identified with precision, 1, what the obligation is, and 2, what the force majeure event is, so that we can draw the necessary causal connection between the 2. The second reason is a practical one, and it's important because it will help any party who is potentially in this situation to just try to understand what likely course of events is going to be. And so if we just dive into the question of defining the obligation, it's important, as I said, for 2 reasons, and focusing on the practical for the time being. Obviously, the one question which is going to be at the forefront of anyone's mind in the current scenario is whether it's going to be themselves who may be seeking to rely on force majeure relief if it looks like there are going to be difficulties with the performance of obligations, or conversely, whether it's going to be the counterparty who is in difficulties. And that's important because it means that we have to focus and look quite carefully on what the contractual chain of events looks like in order to get to the bottom of who is going to be the first to default. And it may actually be that it's not who we think it is. So it may be that when we unpack what the chain of events is likely to be, it transpires that there may be an implied obligation on the part of one party which is necessary to allow the other to perform their obligation, which may be the first to be affected. So really focusing in on what the obligation in question is very helpful because it focuses on what the issues are likely to be. There are some particularly difficult questions arising in relation to specific kinds of obligation. So we've been seeing these a lot. So the first is subsequent or related obligations. Now, force majeure is difficult at the best of times, but in contracts where there are a series of interrelated obligations to be performed by both parties over the course of a period of time, it's incredibly difficult. And there is an understandable concern that where one obligation is affected and therefore excused by force majeure, what does that mean for other subsequent obligations? The legal answer to that is that there is no automatic provision for what is to happen to those subsequent obligations, although there may be a provision in the relevant contracts. We'll talk about that in section 5. And a particularly problematic species of related obligation is payment obligations. So, of course, if you are the recipient of goods or services which are either not delivered or are delayed or are suspended as a result of present circumstances, and where that suspension or non-delivery is excused on the grounds of force majeure, you'll understandably be concerned to understand whether you must still pay. And again, the legal answer to that is that there are no automatic consequences following an earlier obligation being excused on the grounds of force majeure. So unless it's in the contract, the theory is that you may still be required to pay. That's all, of course, subject to the question of whether there may be some implied terms that we can argue for, which would soften the apparent harshness of the conclusions that I've just expressed. But that's obviously another topic in itself, and usually quite a difficult thing to deal with. So I'll hand over to Nick now to talk about stage 2.
Yes, that takes us onto stage 2, which is the event that is being said to be a force majeure. There is no general definition in English law of force majeure, and there are a number of different ways of defining force majeure contractually. Broadly, they fall into 3 categories. Firstly, you have a closed list, which is where you have a finite list of events or circumstances that will be an FM event. The second option is a general description. So, for example, you might have something that says any circumstances beyond the party's control. And thirdly, you might have an open list. In other words, you have a list of specific events or circumstances followed or preceded by some general wording. And that is probably the most common approach taken in commercial contracts. There are 2 issues that arise. The first is a general principle, which is whether or not the justem generis rule applies to open list clauses. This is a principle of statutory interpretation, also often applied to contracts. The effect of the rule is that general wording that follows specific wording is assumed to be qualified or limited by the earlier specific wording or examples. It does not automatically apply to clauses in commercial contracts, but the principle may influence the construction of the general words. And the best example of this is the Tandrin aviation case in 2010, where a party argued that the economic collapse of the financial market fell within the general phrase of any other cause beyond the seller's reasonable control. In that case, the court held that these words have to be read in the context of the whole of the clause in question. And because there was nothing in the earlier list of examples that was connected with an economic downturn, the force majeure clause was not triggered. So if you do have an open list, the first point to check is whether the general wording comes before or after the specific examples, because it could be important. The second issue is a COVID-19 specific point, which is whether COVID-19 falls within some of the circumstances or events that are often described in conceptual terms in contracts. The first of these is an act of God, and a lot of the questions we have received have focused on this too. Most of the authorities on this question concern weather events, so they're not directly applicable, but there are some general principles that emerge from these cases. The first is that the event needs to be a naturally occurring phenomenon. Secondly, it needs to be without precedent or exceptional. And thirdly, it needs to cause unusual violence. As you can imagine, there are 2 schools of thought on this. The key issue is going to be whether or not COVID-19 is a man-made or naturally occurring phenomenon. One of the problems is that we don't really know enough about its transition to humans and then onward transmission. My own view is that COVID-19 is an act of God, but this could well be an issue that makes its way to the Supreme Court. Another example is epidemic, which is more common to see in contracts. One of the issues that may come up is whether there's a distinction between a pandemic and an epidemic. And whilst technically there is, our view is that this technical distinction is unlikely to be carried through as a matter of construction into clauses which expressly list epidemic as a potential force majeure event. So, in other words, epidemic, we think, will cover both an actual epidemic and a pandemic. Finally, we've seen parties using the current circumstances and looking to rely on an act of God. An act of government, which is also often appears in force majeure clauses. Our view is that it's likely, for reasons of causation, that guidance issued by governments will not be enough. The Government Act will need to be mandatory. A more difficult situation is where the government's position is quasi-mandatory. So, for example, a mandatory government order preventing all but essential travel. that introduces an element of subjectivity that will give rise to some uncertainty. So what is essential in this particular context? And I think the answer to that is that we're going to have to look at some of the other guidance that sits around that governments are putting out in relation to what is and what isn't essential, and we see that being updated on an almost daily basis. So that takes us on to stage 3 and causation.
Thank you, Nick. And this, we think, is going to be where the real battlegrounds potentially lie. It's of vital significance in the context of any discussion around force majeure that there is a clear causal connection between the obligation that is not being discharged and the event in question. But that's particularly the case here, I think, because what we have seen and what seems likely to continue is a lot of parties simply saying, well, COVID-19 is the problem. Does that fall within my clause? I am prevented from performing because of COVID-19. And I think as a matter of causation, that's potentially quite a difficult argument, or at least it's a potentially problematic argument that may unravel when we try to draw the clear connection that we need between obligation and event, because what is probably the case is that it's not COVID-19 itself that is causing the problem, or that's causing parties to be unable to perform their obligations, but the kind of consequential circumstances surrounding it. So, as I say, never more important than in the current situation. And causation is one of these questions which, in common with most things in the context of force majeure, depends very particularly on the circumstances and on the clause in question. So it's quite difficult to kind of take you through any particularly helpful general statements of principle, but here goes anyway. Before we come and look at what the clause says and what the clause says is required in terms of causation, whether it's prevention, hindrance, delay, or something else, there are a couple of generally applicable sort of legal propositions that will usually, but not necessarily, apply. The first one is that the force majeure event in question must be the sole cause of the non-performance. There's recent High Court authority on this question, and specifically in the set of circumstances where there were two causes of a party's non-performance. One was accepted to fall within the force majeure clause, and the other one was accepted to be something which was not force majeure at all. And the fact that both of these were causally operative on the party's failure to perform meant that the party was unable to rely on the force majeure clause. So the force majeure event must be the sole cause of the non-performance in question. A related proposition is that the party who seeks to rely on the force majeure clause must usually be otherwise ready, willing, and able to perform the contract, but for the force majeure event. And that gives rise to some difficulties in the commercial sphere, of course, because what businesses, many of you may be doing this, what businesses will naturally be doing is looking at their obligations and trying to ascertain whether, if the worst comes to the worst, they will be able to rely on a force majeure clause. Now, that's fine, but what these recent authorities highlight is really that force majeure is, for a number of reasons, almost like an emergency remedy. It's not something that you plan to avail yourself of. It's something that you may have to avail yourself of if the circumstances so present themselves. And so that means that, generally speaking, a commercial decision not to perform because of a set of circumstances which may or may not be force majeure, it is really quite a difficult situation for a party to be in, because by definition it's not necessarily the events themselves that have caused the non-performance, but rather the commercial decision not to do so. So that's something that we have to be very careful of, and it's something that we have to be very careful in terms of the paper trails that we create. Moving on to the clause itself, there are different flavours of force majeure clause, as I'm sure you'll all have seen. There are clauses which require that the force majeure event must prevent performance. There are those which require that performance is delayed as a result of the force majeure event, and there are some that require that performance is merely hindered. Prevent we can deal with quite quickly. The general principle there, although again this is not universally applicable, but the general principle there is that performance must be rendered impossible legally or physically by the force majeure event in question. Delay clauses are very difficult, or clauses which require that performance is delayed are very difficult, because there is a surprising paucity of authority on what we actually mean by delay in this circumstance. There's one school of thought that says that delay simply means that timely performance is impossible. But there is an alternative school of thought which says that actually the delay standard may be slightly softer. I think for present purposes, what we should have in mind as a rule of thumb is that the former is correct. So where you have a delay clause, you should be shooting for the scenario in which the timely performance of the obligation is rendered impossible. There are reported cases where some different or some softer standard is applied, but those are in quite specific factual circumstances and in relation to quite specific clauses. So again, we come back to the general proposition that we must always look at the facts and the clause in question. But certainly for delay purposes, the rule of thumb ought to be that timely performance is prevented. When we come to hindrance clauses, these are the widest of the lot. And again, there is surprisingly little authority for what we mean specifically by hindrance. And in fact, that authority which does exist isn't always pointing in the same direction. So a particularly difficult question which we've been coming across a lot is, well, what happens if the obligation is simply rendered more expensive? Will that be enough to engage a hindrance clause? Now, generally speaking, you may well have seen general statements of principle about force majeure and about obligations simply becoming more onerous. Generally speaking, an obligation becoming more onerous does not equal force majeure, although it will do in the context of a hindrance clause. But probably what won't be enough is if the obligation simply becomes more expensive to perform without there being some attendant additional difficulty in terms of entering into alternative arrangements with different suppliers, or rejigging supply chains, or rejigging supply routes. So more expensive in itself, probably not enough even to engage a hindrance clause, but pretty much anything else which renders the obligation more onerous is likely to engage a hindrance clause. Back to Nick now to talk about stage 4.
So yes, that takes us to stage 4 of the analysis, which is procedure. And essentially this is about checking if there are any formal requirements that need to be complied with in order to benefit from relief under the force majeure clause. And there are typically 2 issues to look out for. The first one is notice, and often notice will be a condition precedent of obtaining force majeure relief. So look out for words such as provided that or similar. In most cases, the requirement to give notice will stipulate what information must be provided in the notice and when the notice must be provided. But there are a few questions to have in mind. The first is the notice of the event or circumstance sufficient, or is there an obligation to notify of risk or expectation of an event occurring? Secondly, what details must be given of the event relied on? Can you simply say COVID-19, or do you have to go into more detail? Probably the latter. Thirdly, do you need to estimate a duration of interruption? And that's particularly difficult in the current circumstances, given that there is no lockdown exit strategy. And then finally, a timing one. Does the notice need to be served immediately, or as soon as reasonably practicable, or something else? It's also worth bearing in mind that any notice should be given in accordance with the general formal requirements in the relevant contract as to the provision of contractual notices. And we think that compliance with notice requirements will be interpreted very strictly. So think of it as similar to the strict requirements of notification of warranty claims under SPAs. The second issue is mitigation. And the issue of mitigation potentially arises both before the obligation is breached and after relief has been claimed. So you may need to think about whether you have explored alternative options to perform or taken proactive steps to limit the impact of the event in question before the obligation is breached. And then once an FM event has arisen, whether what you are doing what you can to minimize its duration. Often there is an express obligation to mitigate in contracts, but it can be implied too. So, for example, in the Channel Island ferry case, it was found that where a party sought to rely on the general words beyond the control of the relevant party in order to bring the event in question within the contractual definition of force majeure, this would only be engaged if the defaulting party had taken steps to avoid operation or mitigate its results. If there is an implied obligation rather than an express one, it's likely to only apply to mitigation before the obligation has been breached. In either case, mitigation may result in spending money. As Gareth has explained, it is not force majeure where an obligation is simply more expensive to perform. And that then brings us on to the final stage of the analysis, which is effect.
Indeed, and the typical effects of a force majeure clause, as you can see on the slide there, is that it's suspensory in nature, which means that it suspends the obligation to perform, so whatever the obligation may be. But of course, that's only the beginning of the story, because as we said when we were talking about stage one, there are a number of further provisions that a more sophisticated force majeure clause, which is hopefully the nature of the clauses that we'll all be dealing with in commercial agreements. There are a number of things that a more sophisticated and considered clause might try to deal with. So it might try to deal with, for example, the two particularly difficult or problematic forms of consequential or related obligation that I referred to right at the very beginning. So it's quite common, but sadly not universal, for express provision to be made for what is to happen to payment obligations where the delivery obligation is suspended as a result of force majeure, and so on. The other thing that often appears in contractual clauses, and it's worth keeping an eye out for this, is a right to terminate in the event of a prolonged force majeure event. Now, that provision may not actually live in the force majeure clause itself. It may live in a termination clause. So it's worth being wary and having a look in termination provisions as well as force majeure clauses to see if this is the effect. And we think this is potentially something which may catch unwary parties out in the current circumstances, because, of course, it's tempting to kind of fight the immediate fire that's in front of us by seeking to rely on a force majeure provision in order to excuse or suspend the obligation to perform, whatever the obligation may be. But if in fact that creates a right to terminate if the force majeure situation persists for 30 days, is that really what the party wants or intends to do? Particularly in the current circumstances where, of course, none of us are quite sure how long this is all going to go on for. So that's certainly something to have in mind. There's also the opportunity to just touch briefly upon the common law concept of frustration and the extent to which it differs in its effect from force majeure. Now, of course, frustration is kind of by its nature quite a different remedy, because what frustration does is it brings the contract to an end. It discharges the contract in appropriate circumstances. So that's quite a draconian consequence potentially, and it's certainly something that parties would want to think very carefully about before they seek to invoke the doctrine of frustration. In fact, it's probably the severity of this doctrine that's responsible for the emergence of contractual force majeure clauses. But frustration could be helpful because in some respects it's a broader remedy than force majeure is. So say, for example, you're faced with quite a restrictive force majeure clause which deals only with prevention. Well, frustration may be able to come to your rescue there because it bites not only when performance of the obligation is actually impossible, but also where the obligation is rendered but in some fundamental respect different from what was originally envisaged as a result of circumstances that were unforeseen by the parties. So you can see how in that scenario frustration may be a broader remedy, albeit one with particularly draconian consequences. So it's always worth just keeping the possibility of frustration in mind when approaching one of these problems. With that, I'll hand back to Nick, because we've spoken a lot about law. There are obviously some important practical points that we can hopefully convey, which may be of some assistance.
Thank you. So yes, hopefully that more detailed analysis was useful. What we're going to do is spend the next 5 minutes just talking about some practical tips, which will apply regardless of whether you're a party claiming force majeure or are on the receiving end of a force majeure notice. And the first one really is to have a process for dealing with force majeure. As hopefully was clear from the earlier part of the session, the formalities for claiming force majeure relief are really important. So you might want to think about having a single person or group internally responsible for communications with each customer or supplier, and then having a process which ensures that you do not acknowledge or respond to any force majeure notices received until each is properly reviewed. And kind of linked to that is making sure that the teams that are at the coalface don't have discussions relating to force majeure or potential force majeure issues. And actually this is something that crops up fairly regularly, because often the first port of call is the person that has day-to-day conduct of a particular contract. The second point is really around understanding your contracts, and I appreciate that many of you will have huge numbers of contracts to think about. And so to deal with this, some of our clients have found it helpful to categorize contracts into 2 groups. One where you expect you'll need to rely on force majeure, and a second where you expect your counterparty might rely on force majeure. And so, for example, where you are the recipient of goods or services. Then the key is reviewing the contracts carefully to identify which ones contain force majeure clauses, what impact those clauses may have, and what formal procedural steps are required to engage the clause. Again, I appreciate that can be a difficult task to do manually, and so a lot of our clients are thinking about using artificial intelligence tools to help with that. One word of caution around contract review, however, is to remember that fishing for force majeure is likely to be fatal. So being careful that it's clear that you're looking at your contracts for the right reason, i.e. that you think you're impacted by a force majeure event, rather than the business wanting to use the current circumstances to take advantage of a force majeure clause, is really crucial. The third issue, and this applies regardless of which side of the fence you're sitting on, is exploring, if possible, alternative sources of supply or means of performance. It goes both to whether the force majeure clause is triggered in the first place, the causation points, but also the mitigation points that I covered. But I'm sure that all of your businesses will be underway with that in any event. And finally, if you are in a position where you're thinking about seeking to invoke a force majeure clause, first of all, it's useful to check the usual contractual limitations and exclusions on liability in case any liability for non-performance does not apply. So if a liability is limited or excluded anyway, you might not need to claim force majeure in any event, and you might be better off not doing so. Secondly, if you're seeking to rely on a force majeure clause, think about the formal notification requirements. As Gareth says, the rule is do not produce generic notices, and we see a lot of those. And finally, it's the point that I made earlier, which is to remember that any force majeure notices will have to be sent in accordance with the contractual notice provisions in the contract also. So that brings us to the end of today's session. Hopefully you'll have found it useful. We will be sending around a more detailed follow-up pack, and a recording of the session will be available as a podcast. Please do feel free to drop us a line with any questions that we didn't get time to cover today, or if you have any points that you'd like to discuss, including any of the artificial intelligence tools that we can offer to assist with this kind of process. Finally, just to say thank you very much for joining us today.